Okay, thank you very much, everyone, and thanks, Liam, for coordinating the Zoom side of things. Welcome back, everyone, and welcome to day 2 of our international workshop on the role of science in climate change litigation, where it is my pleasure to introduce the first webinar of today and the third panel of the conference on the role of science in national climate litigation. Before I introduce our chair, I just wanted to make a couple of reminders regarding kind of logistics in terms of questions. You do have a Q&A box on your screens. If you have questions, please do put those in that Q&A box, and Sarah will be able to read those out to the speakers and address them to the speakers as we go, and then at the end in the half-hour discussion that we have towards the end of the panel. Please also feel free to upvote questions. There is the possibility of giving a thumbs up to questions that you are particularly keen on listening to answers to. This will help us decide which questions to prioritize on the assumption that, like yesterday, we might have too many questions for the time that we have for discussion. There is a chat box that you can see. You are not able to send us questions through that chat box. However, it is there for any of the speakers who would like to share any links or other comments with you. That can be done via the chat box. Another quick reminder that the event is being recorded and will be uploaded onto the Berkel website in the next few weeks, but just a reminder that it is indeed being recorded. And with that, I am delighted to introduce Sarah Mead, who is legal associate in of the Climate Litigation Network and Climate Litigation Project Coordinator at the World Commission for Environmental Law, Climate Change Specialist Group. Sarah, the floor is yours. Thank you very much.
Thank you very much, Jean-Pierre. It is indeed my pleasure to welcome you all today to the third panel of this workshop convened by Berkel and Santana University. It will be today on the role of science in national climate litigation. And this third panel comes hot on the heels of 2 fantastic panels yesterday. In the first panel of this workshop, we heard from 3 scientists on the latest findings on climate change. Their presentations were crystal clear, terrifyingly even. We are living in an unprecedented global emergency, which threatens life on this planet as we know it, and time is running out to avoid catastrophe. In the face of the failure on the part of big emitters, including governments, to respond to this emergency, we're seeing more and more individuals and communities turning to the courts. And courts are increasingly responding in their favor. Just this year, we have seen successful cases in Pakistan, France, Germany, Australia, and the Netherlands, all of which add to an already large body of national case law. Science plays a critical role in these cases. At the Climate Litigation Network, where I work as a legal associate, we support individuals and communities around the world, bringing legal challenges aimed at increasing their government's climate ambition. We therefore see firsthand the role that science plays in bringing and winning climate cases. Science is relevant to questions of standing. Can you show that plaintiffs are directly affected by climate harms? Justiciability. Can you show that the court that there exists judicially manageable standards to adjudicate the dispute? Causation and attribution. Can you present science linking the specific harm to climate change? And remedies. Is there scientific analysis to support the order of the court from the court that you seek? More generally, it is through climate science that we're able to communicate to the court the extent and urgency of the climate crisis. It is this that is, in the words of the court in Ligari, a clarion call for judges and the protection of human rights. Us lawyers, so we are a panel of lawyers today, are not, and luckily don't need to be, experts in climate science. As we saw yesterday, expertise abounds in the field of climate science. But we do need to know what science can prove and what it cannot. And we need to engage with the scientific community to communicate what we need to bring successful cases. A recent study by Stuart Smith and others suggests that we could perhaps be doing better in this regard. In the first global study on the use and interpretation of climate science evidence in lawsuits, the researchers found that most cases did not quantify the extent to which alleged impacts are attributable to climate change, and fewer still provided quantitative evidence linking defendants' emissions and plaintiffs' injuries. Moreover, they concluded that where courts identified evidentiary gaps, existing scientific methodologies existed that could have filled those gaps. It is admittedly not always straightforward to fill those gaps. Accessing the right science is often costly and time-consuming. The production of scientific knowledge also at times marginalizes certain voices. If scientific knowledge is objective, what scientific research is carried out is often not. And this has flow-on effects for what litigation can be brought. In the absence of proof of climate impacts and harms, some of the most vulnerable communities will not be able to access justice. So as much as there are opportunities, there are also significant challenges. And this makes panel discussions such as these all the more important and timely. We have, over the next hour, a wonderful lineup of presentations before us. Our first panelist will discuss climate litigation in the Global South and the role, or perhaps limited role, that science has played in these cases to date. Our focus will then turn to the US, and particularly those cases that are seeking compensation for climate-related harm, what we might term backward-looking cases. Finally, our third panelist will shift the focus to Europe, and particularly those cases that seek to compel big emitters to take certain action in the future, so forward-looking cases. So with that brief overview, it is now my pleasure to introduce our first speaker of the panel today. Solene Lin is a law professor at the National University of Singapore and director of the Asia Pacific Center for Environmental Law. Her research on transnational environmental law currently focuses on climate litigation. When she returns to work next month from maternity leave, so we're very happy she's joining us today, she will start work on a book together with Professor Jacqueline Peel on climate litigation in developing countries. And this builds on work that they published in the American Journal of International Law in 2019, which was the first empirical analysis of climate litigation in the Global South. So with that, Jolene, the floor is yours.
Thanks, Sarah, for that very kind introduction, and good afternoon, everyone. Greetings from Singapore. It's 8 p.m., so it's a kind of rush hour in my house right now, so I apologize if there are any running toddlers coming in anytime, but I promise I will give you my full attention for the next 15 minutes and for the whole panel, of course. So before I begin, I'd like to thank the organizers for putting together a workshop on a very important topic in climate litigation and for inviting me to participate. As Sarah mentioned, the work that I'm going to be speaking on today is drawn from my collaborative work with Professor Jacqueline Peel at Melbourne Law School. So I wanted to acknowledge that. So let me just share screen and then I'll be able to roll with the presentation. Okay, let's see. And Sarah, am I good?
Perfect.
Great, thank you so much. All right, so I just wanted to start with this quotation that I'm taking from a decision that was published this year, a decision that was passed this year by the Pakistani Supreme Court. I like the quote because it's just very, it just shows a very a particular view of climate litigation that the courts are taking. So basically the court has said in this that this court should be mindful that its decisions also adjudicate upon the rights of the future generations of this country. It is important to question ourselves. How will the future generations look back on us and what legacy we leave for them? This court and the courts around the globe have a role to play in reducing the effects of climate change for our generation and for generations to come. Through our pendant jurisprudential fight, we need to decolonize our future generations from the wrath of climate change by upholding climate justice at all times. Now, the reason I share this is because there were some presentations yesterday that highlighted the the dramatic change in judicial attitudes in the last 20 years towards climate litigation. And this is an example of a very progressive court, one that has been willing to hear climate lawsuits and to adjudicate on climate lawsuits and to have a very mindful understanding of its role. Yes, not now. Thank you. All right, so just to mention that, so in the 2019 American Journal of International Law paper, we examined 34 cases, and these 34 cases, about 18 of them, over half of them were in Asia, 6 in Africa, and 10 in Latin America. Now, of these 34 cases, 14 were core cases, that is, cases where climate change was a central issue in the litigation, and 20 are what we call peripheral cases, where climate change was one of many issues that were addressed in the litigation. And since then, we've uncovered more than 60 cases. So in about 2 years' time, in about 2 years, we've uncovered more than 60 cases. It's a pretty laborious process because one of the things is the extent of underreporting in developing countries, and also the fact that language barriers poses challenges for our work. But it does highlight that there's a lot of potential in this field of study, and to understand how the Global South offers some very interesting lessons for climate litigation. Here, I just want to briefly give some examples of cases from the Global South. The first one is from Indonesia. Komari and Mayor of Samarinda is a rare core case. The plaintiffs argued that they were climate change victims, and they were victims of climate change, which was causally linked to the government's failure to take climate change into account when issuing permits for coal mining. And the plaintiffs pointed to lots of policies and administrative regulations that required the relevant agencies to act to reduce greenhouse gas emissions. The lower courts ruled in favor of the plaintiff, but the decision was overturned at the Supreme Court level on procedural grounds. The most important thing is that it was a core case because climate change was a central issue raised by the plaintiffs. Maranhão is a 2015 case from Brazil. In this case, the Superior Court of Justice upheld the government's decision to impose a fine for the burning of land to clear it for livestock grazing. And in their opinion, the judges recognized that the restrictions on burning were justified in part by climate change considerations. So here, climate change was a relevant consideration, but was not central to the decision. And that was what we classify as a peripheral case. The last one that I will mention is the one where I quoted earlier, DJ Kant Cement Company and the government of Punjab. In this case, the company had challenged the government's order to shut down all its cement plants and no longer issue permits because the existing plants were causing ecological harm. And the court upheld the government's decision, in part again on climate change. And the way they framed it was that all environmental issues in the end are impacted upon or are intertwined with climate change. So you can't make a decision without thinking about climate change or considering the climate change impacts of these decisions. Now, why is climate change a peripheral issue in most of the Global South cases? Well, first is that in most of these jurisdictions, climate law frameworks are absent or they're less well developed. Secondly, is that in many of the developing countries, the issue of climate change tends to have lower public policy salience compared to other more visible issues, such as poverty alleviation, public health, and air pollution, urban air pollution particularly. So this tends to lead to the packaging of climate change with a range of other issues in order for the issue to have some kind of whole. And the third thing is that and oftentimes we find that case theory has to focus on the non-climate issue in order to bring the lawsuit within a relevant statutory framework. For example, within the framework for a particular environmental court or tribunal, or for air pollution. So what are some of the key characteristics of Global South climate litigation? The reason why I want to go through this is to identify why is it that the role of science has been limited when it comes to Global South lawsuits. So let me just briefly talk about what are these key characteristics. So first of all, it is important to emphasize that these key characteristics don't apply across every single jurisdiction, because there are many, many jurisdictions in the Global South. It's a large grouping of countries with very contrasting socioeconomic conditions and political systems. But we do think that these characteristics are shared widely enough to consider them as notable features. The first is that the prevalence of rights-based claims. A significant number of Global South climate cases rely on constitutional rights or human rights, including alleged violations of the right to life or the clean environment. So we think that, well, this is because this higher percentage, or the relatively high percentage of rights-based claims in the Global South is due in part to the fact that many of the constitutions in the Global South contain environmental rights. Enforcement. So the regulation forcing litigation that pursue a climate law reform rationale similar to Massachusetts and EPA and Urgenda is notably absent in the Global South. Instead, what we have identified from the case law is that Global South climate cases demonstrate this preference for the enforcement of laws and policies that already exist. So instead of trying to push for new laws or better climate laws, most of the times the litigants in these cases are trying to push for the enforcement of existing laws. And finally, we use the term stealthy to convey the sense that in the Global South, climate litigation seeks to advance cautiously and quietly by packaging the climate change issue with less controversial claims, largely because there are concerns about judicial reluctance to engage with climate change because of the doctrine of non-justiciability and also the fear of judicial overreach, but also because climate change can be a politically charged issue in some jurisdictions. So against this background, I think it's not difficult to see that the Global South climate jurisprudence does not reflect much engagement with climate science. Because if climate change is often a peripheral issue, or for strategic reasons is an issue that's being downplayed, then it's not surprising that the litigation doesn't feature much of the science related to climate change. Further, it's also important to recognize who brings these lawsuits. Many Global South cases are brought by grassroots environmental organizations, local NGOs, which really don't have the resources to bring scientists on board as expert witnesses, and do not have access to the latest climate science. One of the things that we're interested to unpack in our further research is the kind of global networks that connect a lot of these local NGOs to bigger NGOs, particularly in the global north, that has led to a transfer of knowledge and resources. But still, at the moment, the vast majority of climate lawsuits brought in the Global South are actually brought by very local grassroots organizations which don't have the resources or access to the latest climate science. We also need to consider the attitude of the courts. There is a high level of judicial deference to the regulator in most of these courts. And at best, the court will scrutinize the procedural soundness of the decision-making process. For example, in a judicial review, for example, that the EIA failed to take into account climate change, but they will not, go towards challenging or even towards a scrutiny of the scientific basis for these decisions. Now, it's also important to recognize that climate science, particularly attribution science, right, it's particularly relevant to establishing causation and for the apportionment of liability. But none of the cases in the Global South docket are really seeking compensation from the defendant. And so as a result, to the best of my knowledge, there has just been no engagement with attribution science in this body of case law. I know that there are cases like the case of Ludia, where it's a Peruvian farmer who was trying to sue a German company, but this we don't consider in this docket of cases because the case is being brought in Germany. But there's a very interesting discussion to be had there about transnational litigation involving defendant companies in the developed countries and the plaintiffs being from the global south. There are some interesting cases which I can go into further detail, but I'm conscious of the time that I'm taking, where illegal logging cases, for example, in Indonesia, where no scientific evidence was presented to the court to justify why the defendant was being made to pay for the loss of carbon sequestration potential of the land. And it would have been very interesting to see how the case could have been built in a much more robust way if there was proper scientific evidence admitted to the court. So I think that all points to a vast possibilities that remain unexplored, because at this point in time, climate litigation in the global south is still at a very early stage of development, about 20 years behind developments in the EU and the US and Australia, and insufficient resources remained not available to litigants in these countries. I'm happy to take questions later. Thank you.
Wonderful. Thank you, Jolene, for that wonderfully interesting presentation. I think often we're very much focused here in the global north on cases that are, closer to us. So it's really interesting to kind of expand our focus towards those cases that are being brought in the global south. With that, I will hand over now to Daniel Metzger. He is a climate law fellow at the Sabin Center for Climate Change Law at Columbia Law School. His work focuses on climate litigation in the US and internationally, with a particular emphasis on the intersection of the law and climate science. Alongside speaking and writing, he manages the Sabin Center's Attribution Science database, which we will include the link in the chat for the attendees today. Before joining the Sabin Center, he was an attorney in private practice. We are delighted to have Daniel here with us, so I'll hand over to you now.
Great, thank you, Sarah, for that introduction, and I'll just get some slides shared as well. Is that looking all right?
Perfect.
Great. Well, good afternoon, everyone. First, I also want to thank our hosts for putting together this panel. It's such an interesting and timely topic, and I'm really pleased to be here. I would, of course, much rather be speaking with you all in person, but I'm glad that we can make this happen remotely. As Sarah mentioned, I work at the Sabin Center for Climate Change Law, which, for anyone who isn't familiar, is essentially a think tank at Columbia University where we develop legal techniques to fight climate change, train law students and lawyers in their use, and try to provide the public with up-to-date resources on key topics in climate law and regulation. So my goal for this portion of the panel is to talk about some key cases in the US context, and then use those to tee up some of the legal questions into which attribution has special insight. The cases I'm focusing on primarily deal with liability for past contributions to climate change. So hopefully these will be slightly different issues than some of what Jolene has covered, and we can have a good Q&A session at the end of our time here. I'm going to start by discussing very briefly some background points and litigation statistics, and then jump into those core questions. And if we have time, I'm also hoping to discuss a little bit about the role that science has to play at trial and in hearings, and in particular, how lawyers can defend experts that might present some of this information. And I'll share a few resources with you as well to conclude. So very quickly, as many of you know, the Sabin Center maintains a database of climate change litigation around the world. This slide is intended just to communicate the breadth and frequency of those cases. And as you can see, while the majority of what we've tracked is in the United States, there's litigation happening everywhere, and these numbers are growing continually. For each of the cases we track, we do collect some information about the source of legal obligation that the suit is premised on. And so as of our last analysis we did, the data overwhelmingly showed that the cases were based on statutory or policy causes of action. And so those cases include ones that deal with environmental review requirements, challenges to, challenges to policies that are inconsistent with national legislation setting climate change goals, and cases that cite statutes not designed explicitly to deal with climate change, but that can be applied to climate impacts. The US cases I'm focusing on today fall into the smallest of these categories, the common law or tort actions that seek compensation from parties that had a role in creating the climate crises. And these cases are part of a wave of very similar lawsuits brought by governments all around the country. And there's more than 24 pending as of now, and the number is growing all the time. The cases are filed by state and local governments against fossil fuel producers. And they assert, as I mentioned a moment ago, tort or tort adjacent theories. So those include classic torts like nuisance, negligence, and trespass, as well as statutory equivalents in consumer protection statutes and regulations that ensure accuracy in advertising. And they're all grounded in the notion that the company's conduct was unreasonable or wrongful. And the argument that they make is that by producing, using, and marketing fossil fuels, those companies contributed to climate change, and that climate change is having adverse impacts that entitle those harmed to some compensation. None of the cases claim that a single defendant is entirely responsible for any specific climate impact, but rather that they all share some responsibility for the problem as a whole. So the unifying idea is about assigning responsibility for climate change and doing that in a way that requires quantifying a defendant's share of all greenhouse gas emissions. And before getting into how the climate science shapes the argument, I just want to suggest a couple of reasons why I think this wave of litigation is happening the way it is at the moment. First, there's a significant amount of documents out there that have allowed plaintiffs to build an argument that these companies deliberately spread misinformation and to clearly describe their historical contributions to climate change, which is going to be particularly relevant to the source attribution questions we'll have as we get into the science. And second, these suits were a way for progressive political leaders at the subnational level to press for climate action, even while President Trump was in office, since the collective sense, correctly, I think, was that during his term, we wouldn't see much happening at a national scale. So with all that said, I want to try to dive into how the attribution science works in these cases in a way that might suggest similar applications in future cases. And many of us are very familiar with statements about how important climate science is for legal work generally, but I want to try to get very specific. So this is really the heart of what I'm trying to cover today. Each of these bullets are a challenge that parties in litigation have faced or likely will face when they bring a case. The damages cases in the US have not proceeded to the merits and certainly not to the point of a judgment yet. But when they do, the court will be looking to the parties to come up with some defensible way to say exactly what share of responsibility for climate change each defendant bears. Source attribution, studies like the Carbon Majors report, provides one way for them to do so. And the lawyers arguing these cases can develop an evidentiary record that includes historical information on what types of fossil fuels were produced and in what quantities. Experts can then testify on how to translate those quantities into atmospheric carbon contributions, and then on how changes in the atmosphere produce extreme weather events and other climate impacts. And there's obviously some uncertainty at each stage, but the methodology is there. On the second question, demonstrating that specific impacts are foreseeable enough to justify responses, the facts of a particular case will shape how this analysis plays out. One area where I've seen this in my own research is in cases that challenge government responses to climate change as unjustified. So these are cases where a government in the US, usually a local government, takes up a regulatory change to adapt to a changing climate. Opponents of that measure then argue that climate impacts are impossible to foresee, so it's not a good use of government resources to address them. And the science steps into that debate to precisely describe how much more likely impacts are in a particular area. And even where a specific impact can't be precisely forecasted, qualitative descriptions might help fill that gap. So for one quick example, our electric utility here in New York recently underwent a climate resiliency study that's been discussed as a model for how a private company can use attribution science. They concluded there'll be a significant increase in the number of days with temperatures over 37 degrees, a 20% decrease in cold weather days, and extended heat wave events all throughout their service territory. And the company is now using that information to make all kinds of decisions about which pieces of infrastructure to prioritize for replacement and how to design capacity changes. As far as I know, it's not the subject of litigation yet, but it's of course not hard to see how that same information could be used to defend the steps that a party like that would take to prepare for climate change. And my strong sense is that having a specific quantified number for the way risk has changed is going to be much more persuasive to a court than a high-level description of climate impacts. And the third and fourth questions cover similar ground. We've seen a bunch of cases filed that argue that a company or government has ignored climate risk. And I would include in that category cases against governments alleging insufficient climate mitigation targets or alleging that those targets are not actually resulting in emissions reductions. Here, the attribution science provides a concrete way of describing specific measurable risks that should have been disclosed or should have been addressed. So rather than generally asserting that a company's disclosures don't say enough about climate change, a litigant can argue more forcefully and make assertions like, I have a study here that shows that climate change is making heat waves twice as severe as they were in the past, but the company has said nothing about how that will affect its business. Or to say, I have a study showing that violent storms are happening with triple the frequency they did over the past decade, but the company has no plan for how it will prepare for those events when they take place. So those are still fairly general examples, but I hope it puts some specific applications in mind for how new studies that come out showing those connections and showing things like an increase in frequency of heat waves can actually be used on the ground in an advocacy context. So I included this slide just to quickly pause on this table to provide an example of the results of the kind of source attribution methodology accounting I described a few moments ago. This is the kind of data that litigants are using to come up with figures for what share of climate change major fossil fuel companies are responsible for. And you'll see many of the defendants in some of the major suits that have been discussed, I'm sure, throughout other panels. So I'm aware that we don't have a huge amount of time, but I want to just talk briefly about defending science at trial. And I included this slide to touch on a few of the challenges that my colleagues and I have seen and forecasted in this space. Since few of the climate cases, at least in the US, have gone as far as a trial, we haven't seen the full scope of what defendants will argue, but some of the challenges are already evident. Confounding variables are an obstacle, and as I'm sure virtually everyone is aware, it's difficult to isolate climate forcing from other variables that have a role to play in whether a particular impact takes place. And even among human causes for an impact, the results may be complex. So for example, ecosystem damage in coastal areas may be driven both by ocean temperature increases and acidification, but also by overfishing and pollution. And that's something that lawyers at trial will have to find a way to manage those uncertainties. The strategies to defend against those criticisms that I'm going to describe are all themed around clear communications of research limitations. So if you take one point away from this slide, I hope it will be that clear communication about the limitations of science is the best way to ensure confidence in its findings. So one way to address confounding variables is by not doing it. Single-step attribution studies only look at one link in the causal chain without attempting to make the whole connection from emissions to impacts. And so by identifying the variable being studied and acknowledging that it's not the only one at play can take some of the force out of criticisms based on confounding variables. There's also multi-step attribution studies, as you know, but I think those are going to be a tough sell in courts since there's a possibility of cascading uncertainties at each level. And it is possible to describe the results of a study in a qualitative way, even if a quantitative result isn't available. But as I think I've said earlier, the strongest arguments, in my opinion, are going to be ones that rely on hard numbers rather than a qualitative description, even though I certainly think there is an important role for qualitative description of how climate mechanisms are operating. Another key challenge is the difficulty of attempting to model impacts at finer scales than the models themselves operate. And one way to manage this is to express risks in terms of a region and allow for the inference that a specific site within that region is going to experience the same effects. So for example, a study showing an increased number of hurricanes in the North Atlantic may not include data at a fine enough scale to predict the impact on a particular city, but sitting here as I am, we can infer that because New York is within that area, we're likely to experience at least some of the effect of an increase in hurricanes in the North Atlantic. And last, I think one area that lawyers I've spoken to have expressed some hesitation about is studies that convey their results in terms of degrees of confidence rather than a ironclad conclusion. And I really think that shouldn't be a problem, since burdens of proof and other legal tests are obviously different in every jurisdiction, but almost always flexible enough to allow for some managed uncertainty in the evidence that's offered. So in quickly closing, I want to just mention two resources that may be of interest to this audience. As Sarah mentioned at the outset, we've fairly recently launched a climate attribution database that includes a repository of abstracts of as many of the most recent and pertinent attribution studies as we can. These are thematically organized in a way that made sense to us as lawyers, and many of them are geographically tagged as well, and it's freely available to the public. And then the climate case chart, where we attempt to collect as much climate litigation from around the world as possible. It's available at climatecasechart.com. We're always updating this and always eager to hear about any matters you may know of that we've missed. So please use this database and let us know if anything is missing. As Jolene mentioned, the language barrier and underreporting in a lot of countries makes this difficult. And I don't mind confessing that we fairly regularly identify matters from some time back that were missed, but we're always in the process of trying to update this and make it as complete as possible. So it's changing all the time. I'll close there for now. Thanks again for having me, and please do reach out with questions for the end. And if there's anything we don't get to, don't hesitate to send me an email, and I really do look forward to our discussion. Thanks.
Wonderful. Thank you, Daniel. That was really interesting. I think those resources are really, indispensable, because often obtaining the science or knowing what science is out there is really hard to establish. And as Jolene said, there are often grassroots organizations bringing these cases that don't have access to deep pockets. So it's really wonderful to have resources that enable these to be easily accessed. So now, finally, it is my pleasure to introduce my colleague, who will be the final panelist today. Dennis van Berkel is legal counsel to the Urgenda Foundation, the organization which many of us know brought the landmark case against the Dutch government. He is also co-founder and director of the Climate Litigation Network, which supports litigation around the world that seeks to increase national climate mitigation ambitions. He has a law degree from Leiden University here in the Netherlands and master's degrees from LSE and New York University. So it is now my pleasure to hand over to Dennis. Thank you.
Thank you, Sarah. It's great to be on this panel with Daniel and Jolene to hear these different aspects and different viewpoints on the role of science in litigation. What I will focus on primarily are cases that look at future impacts, and particularly look at government responsibility for those future impacts. And there are different aspects of science that then come into play if you compare that to, for instance, some of the science that Daniel emphasized, which is very much about what is, or in large part, what is the damage that is already being done and who is responsible particularly for this damage. And there's a big difference between the two, because if you look at, we now, especially in Europe, we've had a couple of cases against governments, not only in the Netherlands, but now also in Ireland, in France, in Germany, in Belgium, where courts found that there was a responsibility on the part of the state with regards to climate impact, and also found that there is an enormous threat with regards to climate change, and that individuals within their jurisdictions are affected. So the question is, okay, what was the science that allowed these courts to come to these decisions? And actually, that is the fairly general level science, you could almost say, that by and large is already provided by the IPCC. And often national institutions that have made assessments of what are the sort of adaptation needs, what are the impacts in a particular country with regards to climate change. And one of the sort of what Daniel said at the end of his presentation with regards to if you say that, well, there is an increase of hurricanes along the Atlantic coast in the US, then it's very likely that it's also going to touch New York. That rationale has been adopted by all of these courts, basically. So even if you for instance, look at the Urgenda judgment, scientific facts that were used to establish that people in the Netherlands were affected by climate change were very much impact studies that looked at impacts a couple of decades into the future with regards to impacts that would happen in the entirety of Western Europe. The Dutch government argued, well, we don't know exactly where this is going to hit within the Netherlands. And the court simply said, well, we don't need to. The fact that these impacts are likely to are going to happen in Western Europe mean that they're very likely to happen also in the Netherlands, and you don't need to pinpoint exactly which part of the country is going to be harmed more or less, particularly at what time. The thing that is relevant is that there is a risk of harm happening, and that this harm is, the fact that this harm is going to happen somewhere in the future is also not, doesn't take away the liability of the state. So all of these courts were able to come to the conclusion that climate change was a massive risk to not only humanity at large, but therefore also to the people inside of their own country. And that on the basis of that, there was a positive obligation with regards to the state to do something about climate change. What you also see, especially in the cases that have been won, is that courts didn't even have a problem with the fact that they didn't know exactly which individual that was going to be. One striking example is the very recent judgment in the Belgian case, where there were 58,000 plaintiffs in that case. And the court simply came to the conclusion that all of these 58,000 co-plaintiffs will be directly harmed by climate change and run risks of being harmed by climate change. So that there are some jurisdictions where the courts have had higher thresholds, especially with regards to standing issues, and that is often particular to those jurisdictions that the harm done to an individual must be somehow different or more severe than the population at large. One of the cases there was in Switzerland, a case of elderly women that argued that they were particularly harmed by climate change because of their vulnerability to heat waves. That case is now going to the European Court of Human Rights in Strasbourg. And the question there will be with regards to the human rights protection that the European Convention of Human Rights gives, whether this criteria that you're specifically harmed different from other individuals is the right standard when applying human rights standards. If you look at how the Dutch court applied the same, the convention, the Dutch court said, well, that's not necessary. The articles of the European Convention foresee to also protect the population at large. So there's no requirement for this specificity when it comes to human rights protection. So there we have the impact. So where in these cases is it then all done and dusted? Science doesn't have a role to play in these types of cases. Of course, it still does. But what we see is where the most important part where the scientific questions arise are with the question of, well, if there is a duty to protect, then what exactly must the countries do? Countries are saying, well, we're already lowering our emissions. We have plans far into the future to go to zero emissions in 2050. So we're all good. And there are two sort of aspects to where the science come in. The first one is the timing of emission reductions. And there, all of these cases have basically used this concept of the carbon budget, which was first introduced in the fifth assessment report of the IPCC, and then was again refined in a special report on 1.5. And that is, there is a certain amount of emissions that we can emit before you reach a certain temperature target. So it's not about how much you emit at a certain point in time, but it's how much you cumulatively emit. And this concept has been extremely effective in the context of these cases to explain to courts that it really matters how much you reduce in the short term, and that you can't keep postponing and saying that there will be some grand technology somewhere in the future that's going to solve it all and you'll get to the reduction target that you set yourself. The other bit that is somewhat connected to this is, well, but then how much should countries be doing? And there, what we see is that courts are looking at science, but also at how science can help to interpret also legal principles. So there's an interaction between legal principles and science, and that is that courts are saying, well, if we know that the danger limit is 1.5 degrees, because that is being recognized by the countries themselves, then we also by and large know how much the total cumulative emissions are that are still left. And then it's more a question of, okay, how do we divide up that pie? How much of those remaining emissions are still available to this particular country? There's a body of research called called effort sharing methodologies mainly, or equity literature. It's also mentioned of scientists that are really engaging with this question. What if you look at different principles of international law, equity come with differentiated responsibilities? How should you be dividing the remaining emission space? That literature and the outcomes and the assessment of that literature was the basis also for the reduction order Urgenda case. In the German constitutional case, you also see the court very much engaging with the concept of the carbon budget, how that carbon budget must be divided on a fair and equitable base between the different nations. There's more a necessity for more research in that field. There's a very important, I believe, very important upcoming paper coming up by Professor Lavanya Rajamani and some other scientists that have looked at particularly what if we apply principles of international environmental law to these effort sharing methodologies? What are the outcomes that we see? And I think that we'll need more of that, and also advocacy basically at the national level for that type of research to not only be produced by individual research groups, but also demands that the government or government-related agencies produce that type of analysis. Because one of the things that you do see in these cases thus far is that courts are particularly comfortable with relying on science when it comes from government-related institutions, and they're much more hesitant to base their entire decision on individual papers. Those individual papers and research will play a very big role also in the future, especially when it comes to dealing with the now already unavoidable impacts. Are governments really doing enough to actually protect us against the impacts that are going to happen, regardless of how much we reduce emissions at a fast enough pace? I think especially this year and the past couple of years, which are really, the message is hitting us every day on the 8 o'clock news that climate change is really here. And the questions of, are governments actually not only doing enough to reduce emissions, but are they doing enough to protect us against the next storm, the next heat wave, etc., are going to be more and more pertinent. So that research with regards to the type of research that Daniel pointed out in that type of litigation is not only going to be massively important with regards to responsibility of corporations, but I also believe with regards to responsibility to protect against climate change, not only by reducing emissions, but actually also by investing in adaptation measures. I'll leave it to that, and I look forward to any questions that the audience might have.
Wonderful. Thank you, Dennis, for that. Raising the various kind of complexities around establishing what emitters need to do legally going forward, and the science, the role of science in determining that. We do have some questions from the audience, and we have plenty of time. So if the attendees would like to still pose some questions in the Q&A box at the bottom, that is very welcome. And also, if you're attending, if you click the little thumbs up icon below on the questions that you like, then those ones will float to the top, and we will hopefully get a chance to answer them. The first question, though, is one that I would like to pose from myself to the panelists. And I would like to know, and it relates to the independence of scientific research for the courts. So, and this is in fact from my colleague. I asked if he had a question that he would pose to this panel. And the question is, how can lawyers ensure that the best available science is available for the courts without raising concerns of independence? So this might be something that's more directed at, well, any of you can answer, but the example is sometimes plaintiffs themselves might commission scientific studies for the purpose of the case. Is there a risk that despite the accuracy of these studies, judges will dismiss them, considering them as biased and tailored to achieve a specific outcome in the litigation? And that as a consequence, should we be encouraging scientists to either directly submit their studies to the court, or to be publishing them in peer-reviewed journals so that they are not tainted by this kind of risk of legitimacy? So it's really a question for lawyers who are preparing these cases, whether this is a risk that they need to be aware of. Dennis, would you like to go first to respond to that question?
I think actually in many of these cases, in most of the cases here in Europe with regards to government responsibilities, there actually haven't been individual experts showing up before court, because only already existing reports were being used. So this is really something more regards to sort of more the backward-looking type of damage that is being done, or are sufficient measures being taken with regards to prospective damage, where you will see this more. And I do think it very much depends on the jurisdiction. In many jurisdictions, courts are actually in charge of appointing independent experts, and plaintiffs can suggest the type of expertise and experts that need to be that the court needs to get in order to decide on these cases. But I think that, or in other words, basically, I'm stumbling a bit, but I guess the short answer is that courts are used to dealing with these types of expert questions and with the independence of experts. And I think that it's in climate change it will be no different. So I don't expect many issues to arise.
And Daniel, did you want to jump in there? Because as Dennis said, there may be more issues with the backward-looking cases.
Yeah, I do want to jump in. And Dennis, I appreciate your point that courts are already used to encountering reports prepared for a specific case or for a set of cases. I think it's a great question. And I also agree with the point you made, Dennis, that government science is typically more persuasive. And I've seen courts being a lot more comfortable accepting studies produced by the IPCC or even national governments than something private. And I think in my hierarchy of most persuasive evidence, I would put a peer-reviewed study published elsewhere even a step above something prepared specifically for litigation. But that said, again, experts are familiar with producing reports in a specific case. They may need to where there is no research that is directly applicable, even though there are methodologies that make that very possible and defensible. So to my mind, it's really a strategic question about how you would conduct the litigation, but it is a possibility. And I think the strongest presentation would use separately published data and then only apply it to the facts of a given case. But if that's not available, you could have an expert do a study just for a case, especially if it's someone who will stand up to cross-examination and can use methodologies that are well established and can be defended. And that's something that, unfortunately, we just have very few examples in the US, at least, of how those kinds of examinations have gone. But I think it's going to be a fascinating thing to see as these cases advance further, how that shakes out.
Wonderful. Jolene, did you want to jump in on that, or shall we move on to the next question?
I'm happy to move on because I think we've covered most of it.
Wonderful. Okay, well, the next question is actually being posed by the seasonal school at Santana, Pisa. So I'll put that to the panelists. That is the summer school that is going on parallel to this workshop today. So Costanza has asked, what is the role of science in the defenses of governments and corporations when they are asked to do more or better? Do they also rely on scientific arguments? Do they refute the scientific arguments brought forward by the plaintiffs? And I think, again, this touches, Dennis will be able to give a relatively succinct reply to this in relation to the forward-looking cases. So I'll hand over again to Dennis first.
Yeah, the strategy here has been in the cases in Europe with regards to government responsibilities very much to rely on IPCC signs and signs from government institutions themselves, precisely because it's very difficult to refute. So what the governments here in Europe have by and large done is not to say, well, it's not true, but there are uncertainties. That has been sort of the main defense. And the response by courts has been, well, the fact that there is an uncertainty doesn't mean that there is not a risk. And the fact that there is a risk already creates the responsibility. So those arguments have been largely unsuccessful with regards to how you divide sort of the responsibility between states. Their governments had said, well, this is entirely a normative question. Science doesn't have any role here to play. And that has been an argument because of that has been, well, there we see progress in how science can help answer this question, but there's still more to be done in that field than in relation to risk or prospective harms.
I'll just chime in quickly if I could say, I think the exact same strategy is what we've seen private defendants doing in the cases in the US. And the difference though is that they have been largely successful. So again, it's not that they're debating or trying to discredit the overall conclusion about the role that fossil fuels have had in climate change, but just to say there's enough uncertainty that it can't yet be the basis for a judgment of a specific figure of compensation. And it remains to be seen, but so far, at least, that's been a successful strategy for defendants in the US.
So in the Global South cases, there hasn't been, because most of the times the plaintiffs actually rely on national studies or IPCC signs. And the governments are not in a, they won't refute the IPCC signs. They'll accept that there's a consensus on that. And it'll be foolish for the government to say its own reports were not reliable. So that doesn't open up that channel. So yeah, I think what we'll see in all the Global South cases, which a vast majority of them are actually brought against governments, is that the debate is not on the science. The debate is on, and often the government would argue that it's the lack of resources that prevents them from doing more and doing better. So I think that would be how I would see the role of science.
Wonderful. Thank you. Thank you for all three of your responses to that question. I now have, and it's interesting actually to hear, I think we're starting to see the difference between these sort of cases where you're trying to establish a specific compensation amount and then those cases where you're trying to prevent risk for the future. So obviously differences in the kind of science that's needed. But the next question that we are going to is addressed to specifically to Jolene. And that is relating to climate justice. And it was that transnational, the types of transnational cases that you touched on briefly. And the question is whether, if she thinks that the transnational litigation strategy of Global South claimants bringing cases in the Global North is more aligned with the concept of climate justice, given the recognition that these countries in the Global North are more responsible for climate change and of course also have more capacity to address its consequences. So I will hand over to Jolene for that.
Thanks, Sarah. I think in terms of the optics and in terms of the story that you can tell, it's very compelling to have these cases where there is a Global South plaintiff against a major oil company in the Global North. I mean, the optics look good. There is this argument that based on historical emissions, yes, that would be more into its climate justice. But I do think that there are limits to that logic because a ton of greenhouse gas emitted now has the same effect as a ton of greenhouse gas emitted in the past. And most of the emissions now that we are very concerned about are in the emerging economies, and these emerging economies are in the Global South. So I think it would be too glib to say that cases against Global North defendants would be more in line with notions of climate justice, and to say that cases against corporations, major oil companies in the Global South, Brazilian oil extraction companies, Indonesian extraction companies. Why should these companies not be just as worthy defendants in the name of climate justice?
I think that leads nicely then onto another question that has been posed first, to Daniel and Jolene. And it's about whether one can expect to see whether this new wave of climate litigation in the US, so against corporations seeking damage, is likely to have a snowballing effect towards other countries. And then handing over to Jolene, whether this type of whether this might lead to a kind of tipping point. Interesting use of the climate term there as well, on the type of litigation we're now seeing in the global south. So that is, instead of mainly seeing cases aimed at stopping unlawful acts and emissions towards government, whether we would start seeing more litigation towards specific sectors and industries like the fossil fuel companies that you just referred to, and the logging companies that you were just referring to in Brazil or Indonesia. So maybe Daniel, for you first, and then Jolene, if you could follow up.
Sure, I'll offer a quick thought, but I'm very interested to hear Jolene's response to this. My sense is that it's not likely that this wave of US litigation will snowball directly into cases around, for a couple of reasons. Even though there is a lot of litigation going on in the US, my sense is that there's a uniquely litigious culture here that's partly driving that fact, and it's not necessarily the case everywhere else. And also the legal framework in the US is ostensibly defendant friendly, but in reality, as it comes to these types of litigations, very difficult for plaintiffs to actually prevail. So I think the only way it may have that effect is if the interest in these cases causes there to be more and replicable science done, and just to draw attention to them. But I think I don't see a clear sort of legal precedential way for these to snowball into jurisdictions elsewhere in the world.
Yeah, Jolene, do you want to step in?
Sure. I largely agree with what Daniel was saying, but I think that there's also these other factors to be considered. First is that there has been an increase in litigation worldwide. I mean, definitely not hitting the levels that we see in the US for the reasons that Daniel has pointed out, but we do see litigants being inspired by these. So and that always there's this thing called the Urgenda effect, and it is there. Whenever there is like the recent case against Shell, so in the Netherlands, that has inspired a lot of discussion in Asia about how that can be replicated in Asia, especially because there's widespread recognition that if you don't have these cases in other parts of the world, then the effect is largely limited to Europe, to the EU. But bearing in mind also that a lot of these companies like Shell are transnational companies. So whatever happens in Europe will have global impact on the operations worldwide. I don't think there will really be a tipping point in the sense that litigation is extremely expensive. The resources are scarce, so you have to be careful with the kind of cases you want to pick. But also, having said that, a lot of the litigation does not necessarily lead to judgments. A lot of the litigation that is taking place against corporations are actually don't reach public domain. So I think that's something to bear in mind, that a lot of the litigation, for example, against banks, you won't really call it litigation because it's not really a lawsuit. It doesn't get to the stage of lawsuits, but there's actually a form of, letter, legal proceedings that legal proceedings will be brought if, there were not further steps being taken, etc. So I think that's also to be taken into account. But there's definitely interest in shifting the direction and looking more at how to put pressure on business. Although I think that given the circumstances in most developing countries, the low-hanging fruit still remains seeking to enforce existing laws and to put pressure on governments.
So that's to say, Jolene, you mean that while, some of these legally oriented actions may not reach the courts, there may still be a lot of sort of change taking place by sort of referring to existing laws and so forth and putting pressure on these companies in kind of pre-litigation sort of actions. Is that what you mean?
There are, no, I think what I was trying to point to was that there has been quite a number of actions being taken, well, legal letters being written, for example, to banks, to shareholders, major sovereign funds, etc. And all this is targeted at putting some pressure on these actors to say that, look, litigation is a viable trend. And that's the idea is because there is this sense that if we do not put pressure on business, then there is no real possibility of decarbonization, particularly in the global south.
Okay, so that's, I suppose, the impact of litigation even beyond borders, just for the fact that there is litigation can lead to some sort of pressure, elsewhere. So the next question we have is slightly more technical, and I will direct it to Dennis first, but the others can contribute if they like. But it's around carbon budgets, and many of the attendees will be familiar with the kind of concept of carbon budgeting. And the question is, how often these cases have applied carbon budgets and carbon budgets specifically, which are built into the Paris Agreement goals and national NDCs. And I think Dennis has, well placed to answer this.
No, I think when it comes to government emission efforts, reductions, ambitions, the carbon budget plays a key role in all of these cases. First of all, to explain why it's necessary to reduce your emissions at the short term, but also more specifically, for instance, if you look at the French case, France had set itself sort of interim carbon budget goals towards its target 2030. It was missing those goals, and the plaintiff said, well, at France, the government basically said, well, we still have a chance to get to our 2030 target. So the fact that we are sort of missing our interim carbon budget goals is not a problem. And there the French court saying, yes, it is a problem, because what really matters is cumulative emissions. So this idea of the carbon budget. But also in the German case, the German Constitutional Court based its judgment and the fact that there was that the German Climate Change Act was unconstitutional on a scientific assessment of what the still available carbon budget for Germany would be. It used a report by the Advisory Council on Environmental Issues in Germany that had made a report on the German carbon budget. And from that report, the Constitutional Court took that if Germany were only to reduce its emissions by 55% in 2030, which was the target that was enshrined in the Climate Change Act, almost 100% of the entire available budget to Germany would be depleted. And therefore it would offload all the responsibilities and the impacts of climate change to a future generation. On the basis of that, it concluded that the Climate Act was unconstitutional. So there you see a very direct application of how that carbon budget was used by courts to scrutinize governments' climate policies and efforts and short-term reductions.
Would either Jolene or Daniel like to jump in on that question?
Sure. Short answer. None of the cases I've looked at ever used the carbon budget approach.
Yeah. Okay. So we have quite a complicated question which is posed to Daniel. So let's see how if I present it well. So our question from Mark Ortega is whether there are broad rules of thumb or principles arising from climate cases which guide how typical milestones of scientific or statistical expressions of degrees of confidence broadly map onto typical legal expressions of standards of proof. So I think if we kind of draw that out, are there kind of, principles that we can rely on, that kind of standards in science, particularly maybe that expressed by the IPCC, which can sort of be mapped onto the legal standards applicable to certain cases. I'll leave it at that, but Daniel could.
It's a great question. I saw that in the Q&A and I'm glad we have a moment to get to it, though my answer I think will probably be unsatisfying. So let me add the caveat first that this is technical and I can't really speak for jurisdictions outside the US, but in the US, we have in a lot of these cases different standards of proof or burdens of proof that have to be met, and they're notoriously amorphous and there's no real statistical backing to them. So there are standards like a preponderance of the evidence or beyond a reasonable doubt, and have kind of general, lawyers have rules of thumbs about saying, well, if it's a preponderance of the evidence, that means it's more likely than not. So there can be significant uncertainty. If it has to be beyond a reasonable doubt, it has to be something like 95% certain, but there's no statistical rigor built into those standards. So at the end of the day, it's up to a fact finder to sort of intuit whether they think it's met this sort of vague standard. So I think, unfortunately, there is no clear way to map levels of confidence onto the legal standards, other than to say that in almost every factual situation I can think of in litigation, there is significant uncertainty on both sides, and it's coming somewhere more in the middle of the range. And it's uncommon in most civil cases to have a situation where you can reach 99% certainty. The climate science is almost always reached far more confidently than courts are requiring in other contexts. There was a really interesting study that came out, I think earlier this year or at the end of last, that if you shoot me an email afterwards, I can share with you, trying to do some of this work and demonstrate that the levels of confidence with which scientists are making conclusions typically far exceed what courts are requiring. And I don't have it at my fingertips, but I can put my hands on that and share that with you. So the short answer is no good way to map it, but my sense is that the science is exceeding any of the relevant legal standards. It's just a matter of articulating that in a way that makes sense to the court.
If I may add to that, Sarah, with an example. One of the questions in these cases is to what level can the temperature rise, and then consequently how much should countries be lowering their emissions. But at the core, one of the things in climate sciences is that we're not entirely certain yet how the climate will respond to additional CO2 being emitted. This is called the climate sensitivity. So we have a range that we think is the case, but usually we communicate on the basis of what is sort of the level in the middle of the range. And to make that very concrete, you can have a certain carbon budget, but that carbon budget only gives you an X% chance of then staying under a temperature. So you might have a carbon budget that gives you a 50% chance of staying under 1.5 degrees of warming, but that same amount only gives you an 85% chance of staying below 2 degrees. So the same emission, in other words, if you follow a certain emission trajectory, if you stay within a certain budget, you still don't have certainty with regards to how much the temperatures are going to rise or not. What does that mean with regards to when a court says, well, you have a duty to keep within a certain range and to ensure that the temperatures do not rise above a certain level? Courts will have, because of this characteristics of climate sensitivity, they're having to deal with the fact that there are only probabilities with regards to how much you emit and how much temperatures are going to rise. And what you see in the case law is that courts have no problem to deal with this, for instance. So Most recent example of that is with regards to the interpretation. I think that's a very interesting aspect of the Shell case, is how the temperature, the long-term temperature target of the Paris Agreement was interpreted. Lawyers say the characteristics of that temperature target is to hold temperatures to well below 2 degrees and to aim for 1.5 degrees. And although that's two different temperature levels, it is seen as one goal, one unified goal. And the way that the court in the Shell case dealt with this issue is that it said, well, if we look at the emission trajectories that are proposed in the special report on 1.5, there is an emission trajectory that gives a 50% chance of staying below 1.5. That same emission trajectory gives an 85% chance of staying below 2. Thus, in other words, there's still a 15% chance of going over 2 degrees. So following this emission trajectory is really the minimum for staying well below 2 degrees and having any chance of still staying on the 1.5 degrees. So it identified one emission trajectory to comply with the Paris Agreement goal. And at the core of that was very much how the court dealt with these different probabilities with regards to reaching a temperature level.
Thanks for that, both Daniel and Dennis. That's really interesting, and thank you for the great question. We now have a question from the floor. I'm going to hand over to Roberto, who is one of the organizers for this workshop.
Thank you, Sarah. Yes, still on this issue of the uncertainty, I wonder whether there are like minimum or maximum level of uncertainties that would make a case successful or not. As you rightly said, the projections for the future can only be stated in probabilistic terms. So I could probably say that there is a 95% chance that we will, the temperature will be above 1.5 degrees by 2035, whatever we do. And then I can probably, the models probably say that if we don't reduce substantially, say by 5% at least every year the emissions, by 2100 we will be above 2 degrees. So you see, these are two levels that were mentioned in the Paris Agreement. Now, if you bring a case in a court where you say, look, scientists say there are these probabilities that something dramatic will happen unless we reduce the whole emission, not just, for example, for in the case of Shell, emission of the Shell business, but Shell should leave all the oil underground, not just not emit and not contribute to the emissions in their business. They should also leave the oil under. So how do courts really do with this? Because I can perfectly see a defendant saying, look, you can, everything is so uncertain, you cannot tell me for certainty whether I need to reduce emission. You cannot give me certainty that if I reduce emissions by 5%, 10%, we will stay below the Paris Agreement level. So how court really handle uncertainty? I'm very curious about this. Thank you. I don't know, it's a question to the panel. Thank you.
Maybe I'll start because of the specific example to the Shell case. Just very briefly on this case, the judgment of the court of first instance against Shell did, as they call it, touch on all three scopes of emissions. So the court found that Shell has a responsibility for the emissions of its own business, but also the emissions of its suppliers and of the emissions of its customers. So the entire chain, the court found that it has responsibilities over its emissions, but because it doesn't have direct control over the emissions of its customers and of its suppliers, it only had not an obligation of result, but more of effort. I'm I'm losing the exact term here, but it had to try and get those emissions down, basically. In that case, what the court said is, well, given the enormous size of Shell as a corporation, larger than some countries, Shell has to reduce its emissions at what is necessary at the global level. And then it looked for some consensus with regards to what are the necessary emission reductions at the global level. And it looked at the emission trajectories presented by the IPCC in the special report on 1.5. Now, the fact that the court, and there you see how big the influence is of how the science gets reported, actually, on how the legal standards are applied. Because in the special report on 1.5, the emission trajectory, which is kind of like the main poster, the poster child emission trajectory, is a 50% chance of staying under 1.5. And this is then what the court also takes. So the court doesn't first say, well, there needs to be a 50% or an 80% or a 90% chance. I'm going to look for the target. It very much looks for a consensus. What is science generally proposing? How is the science then dealt with in the context of these international climate negotiations? Until the Paris Agreement, very much the decisions of the Conference of the Parties looked at the likely chance of staying below 2 degrees, which in IPCC terminology gives you a 66% chance of staying under that target. And then the 66% chance was also taken as a starting point by the Dutch court in the Urgenda case. So yes, courts are able to deal with these uncertainties. Certainty is by no means a necessity. The fact that there's no certainty doesn't mean that there's no risk. The real question is there a risk? And then if there is a significant risk, and well, if it's only a 10% risk, maybe that's not significant enough. Although if the harm is big enough, it might be very significant. But in practice, those questions haven't been asked to courts yet. By and large, they look at standards and ways of how science is being communicated, and then use and base their judgment basically on those standards, such as the example that I just gave with regards to the special report on 1.5.
Okay. Did either of the other panelists want to intervene on that question?
I'll just quickly add, Sarah, that in many of the Global South cases, the court had a qualitative answer to it rather than a quantitative response to uncertainty. They basically cited the precautionary principle and just said that based on precautionary principle, we should err on the side of caution, blah, blah, blah. And so it was always a qualitative response.
Thanks for that, Jolene. The precautionary principle probably should have, we should have maybe raised it earlier in the discussion, because it's really critical to the role of science in national climate litigation. We're dealing with the risk of irreversible consequences, and it is, essential that when we're dealing with an existential crisis, that it's treated as such, and the precautionary principle should lower the need for, exact certainty with scientific impact. We will. I'm going to turn to a final question for each of the panelists before we wrap up. There are still some really good questions in the Q&A box, so if the panelists wish to answer them by text, please do so. But the question I want to ask is very quickly, if each of the panelists, before we conclude, could say, do they see the role of science in national climate litigation, particularly in the region that they're looking at? Do you see that likely to change? Can you point to any trends that you think will change in the future, and whether there is a need for perhaps judicial training to equip courts, if you think, whether you think that's necessary for some level of training, or whether you think the courts are already well placed to deal with the role of science in national climate litigation going forward. So we will start with perhaps Jolene, could you maybe kick us off? Do you think science will increase cases?
I think that the role of science will increase as the kind of cases being brought become more sophisticated in the terms of how litigants bring to the courts the science and make it become an issue. There is a lot of judicial training being done in some parts of the global south, but not all. I think also another driver for the greater use of science would be when transnational NGOs attempt to bring litigation in the global south, or at least there are partnerships between the global south and global north NGOs to bring litigation. So an example would be the case of Pandi Nayogo, who brought a constitutional court case against the government of India. She was supported by the same organization that has been bringing the Juliana case. So that sort of case was, has been critical for bringing a lot of the science in the Juliana case to the Indian courts.
Okay. And Daniel, do you want to go next?
Yeah, thank you for this question. I mean, for the cases I've been talking about, I would say I don't expect to see the role of science changing, but I do expect the degree to which parties are using it to increase, and the degree to which courts accept that science increasing as well. So I think as more sophisticated cases are brought and the science is used in really thoughtful ways, it will be persuasive to courts. And as decisions are reached and a body of precedent it forms showing courts accepting that science, simultaneously the bar will be lowered. So at some point those will come together and we'll see a lot more successful climate litigation happening.
Yeah, thanks Daniel. And Dennis.
Yeah, I think more and more science is going to be used in litigation because we're going to see more litigation, and that's simply a result of the enormous inertia of the system, of the legal, the societal, the economic system. The changes that we need are so dramatically fast that without pressure from all different sides, it's not nearly going to move as fast as it needs. So you'll see increasing amount of people looking for different ways to use litigation to pressure the system. They're all going to look at science. Science is in the first place what enabled this type of litigation to happen in the first place. So it's going to keep playing a central role. And where I do see that more and more science is going to come in is especially with regards to how are we going to deal with the unavoidable impacts, the impacts that we're already seeing, who is responsible for those impacts, and how who are we going to hold liable for those impacts. That's I think an area of where the relationship between litigation and science, there is going to be a lot of developments there in the next 5 to 10 years.
Okay, well, I think that is a good point to end on. I think yeah, as Dennis said, the key takeaway going forward is we can expect to see more climate litigation. That means we'll see science, increasingly being brought forward in these cases, and in that respect, we'll quite likely see evolutions in the type of science that's being brought as it maybe becomes, as we learn from each other and other cases, how to kind of refine the science to make it as compelling as possible for the courts to understand the kind of seriousness of the situation that we're in. But on that note, I will thank our panelists. Thank you all for joining us today, also the attendees. Would the organizers like to have the final word?
Thank you very much, Sarah. Just 2 quick things. First of all, thank you very much again to the speakers and to you, Sarah, for your excellent sharing of that session. And the second point is that we're now going to a coffee break for the next half an hour, and we will meet back here at 4 o'clock Italian time. The meeting will remain open, so you do not need to log off and then log back on. You can just remain on the line and the meeting will remain open. But please do go grab a coffee or a snack, and we will meet back here at 4 o'clock. So thank you very much and see you soon.
Thank you. Ciao.